Morning, everyone. Thank you for joining the seminar. My name is Mark Ventola, and I'm an attorney with Sheehan, Finney, Bass & Green, and I co-chair the Labor and Employment Group. Along with me today presenting are going to be my partner, Karen Whitley, and Brian Bouchard. Just a couple of quick things before we get into the agenda. I want to let everyone know we're recording this webinar, and it's going to be available for anyone to get on our website and listen to afterwards. We did get quite a number of questions. There are about 300 people on the webinar today, and I would say at least half of you have submitted questions. So we are not going to be able to, unfortunately, address them all in just a half an hour. We are going to try our best to stick to that 30-minute time limit and respect your time because everyone is busy, especially busy at these times. So I want to jump in and let you know what we're going to be talking about today. So our agenda is going to be as follows. I'm going to talk about the essential workforce and the Paycheck Protection Program. Then we're going to have someone talk about the wage and hour issues associated with furloughs, layoffs, reductions in hours, and the other types of things that have been happening to businesses as they try to address the COVID crisis. Also, unemployment considerations have been very high on the agenda for us. We've been answering quite a number of questions there. Karen's going to address the Families First Coronavirus Response Act and what has come as a result of that. One thing I also wanted to say, and I'm going to jump in and get to the first slide and talk about next the essential workforce, but one thing I did want to just mention is I need to unfortunately jump off the call at about the webinar at about 11:15 to get to a board meeting, but I'm going to get into this right now. So the essential workforce is something that we've been getting a lot of questions about. These stem from the orders that different governors have issued requiring businesses to shut down or institute remote work unless you're an essential business. So what do you do when you see an order like that that comes from a governor, whether it's a governor in New Hampshire or a governor in Massachusetts, which is primarily where most of the attendees are from? The governor's orders in Massachusetts, it was order number 13, and in New Hampshire, it was order number 17 for those following the numbers of the different executive orders that the governors have issued, are about 1 month old now, which in these times is essentially ancient history. But the orders date back about a month, and they're saying that essentially all businesses have to shut down and institute remote work unless you are some form of an essential business. So what is an essential business? An essential business is something that I guess, we're going to go back to the essential business slide, please. An essential business is something that is dictated by each of these orders that were issued by the governors. The governors, in turn, relied upon an agency called CISA, which is part of the Department of Homeland Security. And CISA stands for Cybersecurity and Infrastructure Security Agency. That's something that probably none of us had heard about a couple of months ago, but it is an agency that has had in place for a long time a list of what are essential businesses in this economy. And if you go to that website, you can easily find the list of essential businesses. That's exactly what the governors in Massachusetts and New Hampshire and all the other states did. They relied upon this CISA definition and description of essential businesses to come up with their own list of essential businesses. Now, each governor also modified that a bit and adapted it a bit to their own specific workforces and the things that are more or less important in their states. But that's where it comes from. And if you wanted to see more information about it, I'd suggest you go to the CISA website. Now, the governors have taken an approach of more or less adopting CISA, but when you look at it and you look at the orders, you will see that what is an essential workforce is something that's a bit vague and broad. And a lot of different businesses can fit within the broader descriptions of what is essential. To determine what is essential is essentially a self-policing endeavor, meaning that if you look at that list, it is up to you as a business owner to determine whether you fit within the list of what is essential. Now, the websites for both Massachusetts and New Hampshire and the orders will give you a place to go and someone to try to speak to address whether your business falls within essential or not, if it is not very clearly dictated. But good luck trying to get in touch. You can try to do it, but for the most part, this is a self-policing effort. What we are suggesting and what we've seen people do in order to support their workforce, their essential workforce, is provide people with things like letters, memos, badges, with photographs that show what business these people are in, what business they work for, and describe, depending on whether it's a letter, a memo, or a badge, describe more or less why it is essential and how it fits within the essential workforce. The other thing I suggest is that if a letter or a memo is provided to your employees, because we have had circumstances where employees are stopped and questioned about where they're going and why, there be a phone number and someone to speak to. Now, there is also, if you have an essential workforce and your workers are on site, there is a very good one-page paper from the CDC providing guidance about how to run your operation as an essential business. And it won't be anything that surprises most people at this point, but the CDC guidance is very good. It's a nice one-page document that can be printed out and posted in your work site, and will tell you specifically what to do and how to run your business. There are also state-specific guidelines that have come out. Each state has its own guidance about how essential businesses should be run, and some are very specific. For example, if you're in the healthcare industry, or you're in the grocery industry, or you're in the construction industry, there are specific sets of guidelines that have been put out there for you in order to help you continue to run your business. Now, lastly, enforcement. Enforcement, as you might expect, is a little bit difficult given how many people are out there working, how many are in the essential workforce. You're not seeing too much enforcement, although there can be civil and criminal penalties associated with violating the orders. Most of what we've seen so far comes from employee complaints, employees who are being told to go to work and believe they are not part of the essential workforce. That's where you will see, as employers, most of the activity in essential workforce. Okay, let's go to the next slide and talk about the Paycheck Protection Program for a few minutes. We've gotten lots and lots of questions about this. So let's run through this as quickly as we can. First off, who is eligible for this program? In order to be eligible, you have to have 500 or fewer employees. Self-employed, sole proprietors, and independent contractors are included. We also know, and we've seen some cases in the news about the hospitality industry, restaurants, having less than 500 employees at a location. And if they have less than $500 million in sales as a group, they can qualify for this program. We saw that Shake Shack was awarded PPP money, decided not to use it. Other large institutions have been awarded the money as well. Now, nonprofits are also eligible. As for the amount, 2.5 times your average monthly payroll, which includes wages, salaries, healthcare costs, retirement benefits, and taxes. Take that amount, multiply it times 2.5, provided that there's a cap of no more than $100,000 for any employee's salary or wage. And that would be the maximum amount for which anyone would be eligible for the Paycheck Protection Program. It's a great program because there are no personal guarantees required by any business owner, and no collateral is required to be put up. Once the amount of the loan is determined, how can it be used? It can be used to fund payroll costs, same definition I just gave you. It can be used to fund and pay for mortgage interest, not principal, rent, and utilities. And it can also be used to fund and pay for interest on any other debt that was incurred by the business prior to February 15 of this year. Now, the biggest area of question is forgiveness. We know that as part of this program, it's designed so that if used properly, the loan amount can be forgiven. The basic idea here is this, that for 8 weeks after you receive your loan proceeds, provided that you will use it for the allowable uses during that 8-week period, and provided that you maintain the same number of employees and the same level of compensation for those employees, you will achieve the maximum possible forgiveness under this loan. Now, we're suggesting that if you do receive these funds, you put it in a separate account, because tracking the use of these funds is going to be most important when it comes time for forgiveness. The SBA is going to issue very detailed regulations. Right now, we're only looking at draft regulations, so many of the questions about forgiveness we're not able to answer in definitive terms, but we can give you the basic idea, which I just gave you. The other thing to look at is this. When you receive these funds, the SBA is saying that no more than 25% of the funds can be used for non-payroll purposes. So to maintain maximum forgiveness, use 75% of these funds towards payroll. Now, the more complex way to describe it is as follows. Figure out the maximum forgiveness amount. This is how you use the funds you receive for the allowable purposes in the 8-week period after you receive the funds. 8 weeks is the key. These funds are designed to be used in 8 weeks after you receive them, from the moment the money hits the account. Once you figure out what the maximum amount of forgiveness is, that amount can be reduced if your head count, your employee head count, and this is by full-time equivalent, is reduced, or if you reduce the wage and salary levels of the employees, okay? This is designed, it's a program designed to keep people employed and to funds to be used for payroll purposes primarily, okay? What happens if the loan is not forgiven? If for some reason part of this loan, and in many cases part of it, will not be forgiven, you have essentially an interest rate of 1%, so a very low interest rate loan for a 2-year term, and payments that would be required, no payments would be required for the first 6 months. So those are the basics of the Paycheck Protection Program. I know there are lots more questions. I know that lots of you have questions. Hopefully in the near future, we'll be able to answer them in more specific detail as the full regulations come out. I would encourage you to continue to check our website, as there are lots of resources on that, and we are pretty quick to put up alerts when these regulations come out. So with that, I'm going to turn it over to Karen. I believe Karen is next, or Brian, whoever is, actually it's Brian. I'll turn it over to Brian. Thank you.
Thanks, Mark. My name is Brian Bouchard, and I'm an attorney with the firm's Labor and Employment Department, as well as Litigation Department. And I'm going to start my slides off this morning by talking about the Worker Adjustment and Retraining Notification Act. This is a federal law that applies to employers with 100 or more employees, and it requires that covered employers provide 60 days notice for a plant closing or mass layoff. Now, Those are terms that are very carefully and specifically defined in the regulations. The regulations are easy to find. So for this morning's presentation, what I want covered employers to take away is that if you are laying off a group or groups of employees for a period that is going to exceed 6 months, it is possible that you may have WARN obligations. Okay, and that includes, by the way, a situation in which a covered employer may have laid off individuals for a period of, let's say, 2 to 3 months, but now due to worsening economic conditions, it appears that the layoff is now going to exceed 6 months. That may be a WARN type situation as well. It is going to be equally important to consult any mini WARN acts, which are state laws that expand upon WARN in certain circumstances. New Hampshire, for example, has a mini WARN law that for the most part parallels federal WARN with a few minor exceptions. Massachusetts doesn't have a WARN or mini WARN law per se, but it does have some plant closing laws that trigger reporting obligations upon a plant being closed. Moving away from WARN and towards temporary layoffs and furloughs, although that could play a part of WARN as well, it is important to remember that a temporary layoff or a furlough is a triggering event for the payment of final wages. Okay, so in New Hampshire, final wages have to be paid out within 72 hours. In Massachusetts, it is the day of separation. There's also a triggering event for the payment of PTO. In Massachusetts, PTO has to be paid out as a matter of course on the final day of employment. One caveat to that is that the Massachusetts Attorney General's office recently issued a proviso saying that if an employee is temporarily laid off with the expectation that the employee is going to return to full employment, the employee can elect to essentially preserve their accrued PTO with the employer so that it can be used when the employee returns to work. And the Massachusetts Attorney General's office has said that that situation would not be litigated by its office anyway as a failure to pay final wages. Still, you want to be very careful in that type of situation because the FAQs do note that private litigation may still occur. For any employer who's considering a reduction in wages or a reduction in hours, it's important to know that the fundamentals of the FLSA and wage laws still apply. So what that means is that every employee must be paid at least a minimum wage for all hours worked, and that if you have an exempt employee, that person still has to be paid on a salary basis at least $684 a week in order for the exemption to apply. Think also of the notice that you're going to provide for the reduction in wages. A notice should, at a minimum, be in writing, be in advance of the reduction in wages taking place, and should probably also state that the reduction is not retroactive. Now, for those employers dealing with non-at-will employees and they are considering a reduction in wages, it is going to be important to consult the contract between the employer and the employee to see if a reduction in wages is allowed by the contract. And if it is allowed by the contract, whether there are consideration issues that are going to need to be considered before the reduction takes effect. And with that, we're going to shift over to unemployment. There has been a significant expansion in unemployment benefits, and the CARES Act has been at the forefront of that expansion, primarily with its 3 pandemic programs. The first of which that we're going to talk about is the Pandemic Unemployment Assistance, or PUA. And that expands unemployment eligibility to independent contractors, self-employed individuals, gig workers, and individuals who are otherwise unable to obtain state or federal unemployment benefits, including those who may lack sufficient work history or are unable to work as a direct result of the pandemic. Now, for that last category, the CARES Act calls on affected individuals to self-certify in good faith that on the one hand, they are able to work, but on the other hand, due to reasons as a result of COVID-19, they cannot work. Reasons may include being diagnosed with COVID-19, caring for a family member who has been diagnosed with COVID-19, or being the primary caregiver for a child whose school has closed as a result of the pandemic. The PUA program extends for 39 weeks, and it is 100% federally funded through a voluntary agreement between the federal government and the state. Now, it is a bit unclear at this juncture how the agreement between the state and the federal government is going to work. Those are still rolling out. It is possible that in the future there could be some disputes as to benefits falling under the PUA and benefits that may have fallen under traditional state unemployment. Another part of the pandemic programs is the Pandemic Unemployment Compensation, or PUC. I'm sure most people have heard about this program. It is the one that provides $600 in benefits to individuals receiving state unemployment. The USDOL has come out with guidance on this and has said that if an employee is receiving just $1 in unemployment benefits from the state, that person is entitled to the full $600 in extra benefits from the federal government. And as we'll see a little bit later on, that can be a windfall to the employee. The PUC, however, sunsets on July 31st of this year. And finally, there is the Pandemic Emergency Unemployment Compensation, and that provides an additional 13 weeks of benefits to individuals who have otherwise exhausted their entitlement to unemployment. So in New Hampshire and in Massachusetts, there is generally a 26-week cap on unemployment benefits. With the PEUC, those benefits are going to be extended to 39 weeks. New Hampshire, for its part, has issued an emergency order number 5 that has expanded the state unemployment eligibility for unemployment benefits in ways that mostly mirror the federal PUA program. Perhaps most critically, the emergency order amended the rule against denying benefits to those who voluntarily quit their jobs, except in certain circumstances, and has extended eligibility to workers who quit their jobs due to COVID-19 reasons. I think one of the more controversial reasons put forth in the emergency order is that an individual will be allowed to go into self-imposed quarantine in order to stem the tide of COVID-19 and be eligible for unemployment benefits. The good news for employers is that the expanded eligibility under the emergency order number 5 will not be attributable to the employer unemployment count. Massachusetts, for its part, has not issued many formal expansions of its unemployment system, but actually appears to be relying on the PUA to expand unemployment eligibility, and that's what the PUA was designed to do. In fact, I think in Massachusetts, the PUA application program just opened either late last week or earlier this week. The Massachusetts Department of Unemployment Assistance has created an emergency regulation, however, that has some few points that you may want to look into, one of which is the creation of a standby status that allows an individual who has been temporarily laid off with the expectation of returning to not have to look for work so long as they are staying in contact with their employer and they are available to work any hours that are offered. As you can probably tell, there is an expansive catalog of unemployment benefits that are now available. And if you are an employer that is considering a reduction in force or a reduction in hours, you may be able to use both the expanded eligibility for unemployment benefits and traditional unemployment benefits to provide both a benefit to yourself as the employer and your employees. One way to do that is through a work share program. These are formal programs that are administered by the unemployment agency of the state. And what they allow an employer to do is reduce employee wages by a certain percentage, and then the affected employees are allowed to claim a proportionate percentage in unemployment benefits that they may not have been otherwise able to claim because that percentage would exceed the partial unemployment allowance. So the benefit here to a work share program for the employer is that you get to keep trained workers on the payroll and you get to reduce your overhead. The benefit to an employee is that they get to remain employed, at least on a partial basis, and get to receive unemployment benefits in a greater amount than they would otherwise be able to receive. In fact, as you'll see below in the slide, An employee in Massachusetts who's earning $920 a week, but has a 40% reduction in hours, may actually receive a windfall from this type of program by almost $300 per week. And that windfall is actually created by the fact that the PUC is injecting $600 per week in federally funded unemployment benefits to the employee. The drawback from a work share program is that it requires planning. To enact this type of program, an employer has to submit an application to either the New Hampshire Employment Security or the Massachusetts Department of Unemployment Assistance, and it can take up to 15 days for the agency to either approve or deny the plan. These plans are detailed and take time to put together. Outside of the work share provisions, it is still possible for a reduction in hours to take place and for employees to receive unemployment benefits. In New Hampshire, a qualifying individual may earn up to 30% of benefits without a corresponding reduction in their benefits. After the 30% mark, unemployment benefits are reduced dollar for dollar. In Massachusetts, qualifying individuals may earn up to 1/3 of the would-be unemployment benefits without that affecting their benefits. Again, there's a reduction after that. That ends the unemployment benefit part of this presentation, and I'm going to turn you over to Karen to talk about the FFCRA. Thanks.
Good morning, everybody. I know we're running up against time, but I hope you'll bear with me because I think there are some important points on the FFCRA, the Families First Coronavirus Response Act. I have had the pleasure of speaking to many of you about this, and I've been monitoring some questions that came in. I'll try my best to include them in as quick a time as I can. I just want to start by saying there are two forms of leave under the FFCRA, paid sick leave and the expanded family medical leave. It's important to understand the link between what Brian was just talking about, unemployment, and FFCRA. If somebody is currently collecting unemployment, if they've been laid off, if they have been furloughed, they are not eligible to take any type of leave under the FFCRA. So those are two different benefits or opportunities that employees have. So just to go very quickly through the types of leave that were created and took effect on April 1st, paid sick leave and EFML. Under the paid sick leave, there are 6 reasons, although the last reason is still TBD. We don't know what that could entail. The Department of Health and Human Services still hasn't told us. But there are basically 3 buckets. The first bucket is if the employee has to stay home for quarantine, stay-at-home order, or for their own health issues. Because they've experienced some symptoms and are seeking a medical diagnosis, or because they have concerns, that they and have actually sought a medical diagnosis. And that what I want to be very clear on is the concern for somebody's own health without seeking a medical diagnosis is not an appropriate reason for someone to be taking paid sick leave. So the first bucket is the employee's own health situation. The second is if an employee is taking care of somebody who has either a COVID-19 health-related reasons or that is subject to a stay-at-home order or an isolation order. So the employee's own health, the employee is taking care of somebody else who has a COVID-19 reason. And the third bucket, one that spans both the paid sick leave and the expanded the FML bucket, is the requirement that somebody stay home to take care of a child whose school or daycare has closed. And it is important to understand that it's not just that somebody would like to stay home to take care of their child, but that there is no other suitable person to take care of their child who can't go to school or daycare or a summer camp. Because this leave will extend through December 31st if people plan wisely. So it may in fact cover more than just school, but some other care facility that a child cannot, a son or a daughter cannot go to. So those are the two, so those are the 3 buckets. And I want to spend more of my time talking about a checklist that I have on my next slide. So I'm just going to go very quickly through these. The paid sick leave will pay people 2 weeks of time at full pay up to $511 a day or $5,110 if it's for their own health reasons. It will pay only 2/3 pay if they are taking care of somebody else, if they're taking care of somebody who has COVID-19 symptoms, or if they are taking care of a child who can't go to school. So 2/3 pay under the paid sick leave. It is also 2/3 pay under the EFML if somebody is staying home to take care of a child. But it's important to recognize the first 2 weeks of the EFML are unpaid so that people can either substitute the paid sick leave for their own accrued time, or they might take it unpaid. The other important thing is that EFML is a new new FMLA reason, but it is not giving people more FMLA time. So if someone has already taken FMLA time this year, or if they're pregnant and know that they want to have a maternity leave or a parental leave later in the year, they have to be very cautious with how much EFML time they take, because it is the same 12 weeks under the FMLA. The EFML is also the only time anyone can take intermittent leave. And again, that's only with EFML to stay home, take care of a child who can't go to school, and it's only with the employer's permission. Just to talk very briefly about the exceptions to this. There are basically 4. The first is that employers larger than 500 employees at the time an employee takes leave are not eligible for these 2 types of leave. So you do look at, according to the most recent Q&A from the Department of Labor, you do look at how many employees you have, including people who are on leave. So people who are furloughed and may be considered on leave, you would count them. There's a whole group of people you would count to figure out whether you have 500 employees. The other 3 exceptions are the small employer exception. So somebody who has fewer than 50 employees may be able to get an exception from this law on a case-by-case basis based on specific criteria. This is going to be narrowly construed. So you should be cautious, make sure you meet those criteria before deciding you're a small employer who does not have to provide paid sick leave or EFML to your employees. The other 2 are very broad, the healthcare provider and emergency responder exceptions. Those, we started off not knowing exactly who would be included and who might be exempted from this law, with balancing the need to give people leave and the need to have healthcare providers and emergency responders. But the regulations that came out on April 1st make it very clear that this is a very broad category. So you would want to take a good look at whether you fall within, your employees fall within this category, and then also look at specific employees and figure out, do you want to exempt them from paid sick leave and or exempt them from EFML? So you can choose, because you don't have an obligation to give them any leave. If you do, you can give them some. The other thing is documentation. When this first came out, I think a lot of people were following the FMLA guidance. Employers that were larger know that you can ask for a certification or the FMLA. Here, we're not allowed to do that. So be very careful about what documentation you're asking for, but make sure that you ask for the documentation that you should be asking for so that you can justify taking a tax credit. And the tax credit is a big part of this, because you're paying employees their time off, either full pay or 2/3 pay. You're going to be able to capture some of that by taking a tax credit against payroll taxes, and now a larger expanded categories of taxes. The IRS has now told us employers are not just restricted to taking it against a payroll tax credit. So look very carefully at the IRS guidance to see what you'll be able to offset against these amounts that you pay. I'm just going to go very quickly through some best practices. Number 1, prepare a leave request form. Ask for the information that you can ask for, but make sure you're only asking for what you can ask for. And the regulation 826.100 lays out what you can ask for each of these types of leave. Be very careful to only ask what you can ask for, because you could get in trouble and employees could object if you're asking for more invasive information than you're entitled to. Secondly, double check and the advice that you've received in March might not be the same advice now, unfortunately. Things have evolved so quickly with this law that what we thought and what we knew and what we were reading in early March, mid-March, late March, even early April have continued to change. And the Department of Labor put out more questions and answers earlier this week. including how to calculate pay for seasonal employees and providing more feedback about how to calculate the rate that you pay part-time employees that work irregular hours. So there's constantly more information coming up. So check and make sure that just because you had an answer in March and that's the way you were marching, this is now a different time. We've learned more information. And I would suggest that people keep screenshots of what they're looking at if they're relying on a Q&A from the Department of Labor so that you can justify this is why we did something that way. And finally, I would use a checklist. And so the checklist is on the next page that I've been looking at myself. For every employee who's asking for a leave of absence, check and see what is the status of that employee. Have they already been furloughed, so they're not entitled to it? Are they a brand new hire? If they haven't been employed 30 days, they wouldn't be entitled to EFML. Are they full-time or part-time? How much do you have to pay them? Are you a covered employer? How big are you? Are you looking at affiliated joint companies to figure out how big you are? Are you going to invoke these exceptions, the healthcare provider, the small employer, the emergency responder? Look at the covered reason for the leave. Look at the Department of Labor notice that came out at late March and make sure that people who are asking for leave are falling within one of those buckets. And if they're saying, I haven't seen the doctor, but I'm afraid of coming to work, recognize that that is not a covered reason. The documentation, I've said this repeatedly, justify the leave, but limit to the permissible information that you can get. Talk to the employees about the length and frequency of their leave. The EFML allows employees to take intermittent leave if the employer agrees. So talk to the employees about what they're looking at. Do they need a sort of a block leave or overtime? And if they're going to be using it overtime, because say their kids are doing remote learning in the morning but need to be occupied in the afternoon, what increment of time will they be taking leave and unavailable to work? Track the leave carefully because you're only going to be able to get a tax credit for the leave that was taken for appropriate reasons. And then when all this is over and people return to work, monitor the return to work. Monitor that there's no retaliation. So those are just some of the ideas that we've come up with and we've seen and that helped a lot of employers implement over the past month and a half. And as new information comes out from the Department of Labor and from the IRS, we will, I'm sure, continue to get more clarification on many of the questions that you've been asking and seeing every day. So I want to thank you all for your time this morning. And I want to encourage everybody to tune in next Wednesday for Chris Tandon, who will be giving a presentation on the financial considerations that companies are seeing in the crisis. So again, we're sorry that we couldn't answer all the very fact-specific questions that came across to us, but we very much appreciate you joining us and wish you all good health and stay well.